So, good day everybody. I'm Attorney Shay. I am your instructor for criminal evidence. Okay. So, the last time I have uploaded a video introducing the class rules, okay, and a brief introduction of the subject criminal evidence. Okay. I have asked you to make a class reviewer, which will be your final output for this subject. I have also sent you your own course outline and a sample of the reviewer that I was referring to. Okay, so after the video, I ask you to write down or take down notes or questions that you may have regarding the topics covered by the previous videos. And those questions I have compiled and I will be answering them today before moving on to the next topics as provided on your course outline. Okay? So let's start. Okay, so the last time you were able to have a brief discussion of evidence. Okay, we started with the subject proper. Okay, we defined evidence under Rule 128, Section 1. Okay, evidence is a means sanctioned by these rules in ascertaining in a judicial proceeding the truth respecting a matter of fact. Okay, from that definition under Rule 128, Section 1, we were able to get the four components or elements of evidence. Okay, particularly that evidence is a means, sanctioned by these rules of ascertaining in a judicial proceeding the truth, respecting a matter of fact. Okay, so na-discuss natin yung component elements, ng evidence. Okay, also we were able to finish section 2, which actually provides for the principle of uniformity of the rules of evidence. Okay, meaning pare-pareho ang rules of evidence na ina-apply in all courts, in all hearings, in all trials. Okay. Also, we were able to finish section 3, admissibility. Okay, particularly the two elements which are relevancy and competency. Okay, we were able to discuss several topics and concepts. Okay, sa gitna ng mga sections na ito. So, I think you were able to understand most of the concepts. I was also I asked you pala last video lecture, to take down notes and to write questions if you have any. And before I will be starting with the next topics on your course outline, I will be answering them. Okay? So, may mga questions dito na kinumpile ko. Actually, hindi ko na kinumpile. Inalala ko na lang kung sino ang nag-question. Okay. Most of the questions came from section 4A1. Ito yung GC na sobrang active. Like, hanap. Okay. Okay. Section 4A1. Okay. Ayun. Okay. The students from this section asked for a more elaborate discussion on Factum Probandum and Factum Probans. Okay. So, ulitin natin. Okay. Yung Factum Probandum tsaka yung Factum Probans. Okay. Last time, we have defined Factum Probans as, the ultimate fact or proposition sought to be established. Okay. Pag sinabi natin Factum Probans naman, these are the evidentiary matters. Okay. In relation to this Factum Probandum and Factum Probans, dinifferentiate natin yung evidence from proof. Okay. When we say evidence, we are actually referring to the means, the method, the medium of disproving or proving a particular fact or issue. Okay. Nagkakaroon tayo ng confusion kasi nasanay tayo na pag sinabi nating evidence, we are actually referring to the object. Okay. Which, technically are the pieces of evidence. Okay. They are not evidence itself in the technical manner as defined, as understood under Rule 128, Section 1. But they are actually pieces of evidence. For example, this is a knife. Okay. Ito yung murder weapon sa isang krimen. Okay. Inisip agad natin, or most people will refer to this as evidence. Okay. So, kaya na-associate natin yung word or term na evidence to the object, to the pieces of evidence. Okay. When in fact, evidence is actually a means, a medium or a method, of proving or disproving a particular fact or issue. Okay, so yun yung evidence. Ano naman yung proof? Okay, so parati natin na-interchange ang evidence of pieces of evidence. Parati rin natin na-interchange ang evidence at proof. Okay, technically, hindi pareho ang evidence and proof. Okay, pag sinabi nating evidence means method, medium of disproving. Okay, meaning it's a process. Pag sinabi natin naman na proof, these are actually the ultimate facts. Okay, pag sinabi nating proof, ito yung result ng evidence. Okay. Kung ang evidence ay method, ang proof ay ang result. It is the end. Okay. Magigets natin. Okay. So, paano ba natin magagamit yung distinction ng evidence versus proof sa factum probandum tsaka sa factum probans? Okay. Kasi yung factum probandum, it is actually defined as the ultimate fact or proposition, okay, to be established. Yung factum probans is evidentiary matters. So, in effect, pag sinabi nating factum probandum, we are actually referring to the proof. Tama? Pag sinabi nating factum probans, we are actually referring to the evidence. Okay, evidentiary matters, pieces of evidence. Okay, paano ba natin maipuprove yan? Okay, for example, okay, sa section 4A ulit, there was a question. Okay, ano po ang example ng factum probandum at factum probans? Okay, last video, sinabi ko, for example, okay, in a case, okay, in the crime of illegal possession of firearms, okay, paano mo mapoprove na ang isang accused ay nag-commit or nag-violate ng illegal possession of firearms? Okay, you have to prove two matters. Okay, ang ultimate goal mo dyan is to prove, number one, the existence of the firearm. Correct? And number two, the negative fact, okay, of, okay, lack of license or permit to own or possess the firearm. Okay. Ngayon. Okay. Ang factum probandum mo dyan ay actually yung elements ng crime. Okay. Papatunayan mo na present yung existence of firearm at yung lack of permit or license to own or possess. Okay. Yan, itong dalawa, ang tawag dito factum probandum. Kasi kailangan mo itong dalawa para ma-prove mo yung commission ng crime of illegal possession. Okay. So, these are the ultimate facts you need to establish in order, okay, for the crime of illegal possession of firearms to be established. Okay, so, ngayon, ito yung factum probandum mo. Ano ang factum probans mo? Number one, paano mo maipuprove yung existence of firearm? Through the presentation of the firearm itself. Okay. O, paano mo maipuprove yung lack of, okay, permit to own or possess? Through a certification coming from the PNP. Okay. Na wala siyang karapatan to own or possess that firearm. Yung firearm itself at saka yung certification from the PNP, these are actually your factum probans. Okay. So, ang factum probans mo ay yung evidence, okay, yun ang evidence mo to prove the factum probandum. Okay. Yung firearm tsaka yung certificate, these are evidentiary matters, okay, evidence to prove the elements of the crime itself. Okay. So, nagigets na ba yun? Okay. Next topic or next question raised on that section 4A ulit to galing. I think it came from a series of questions na to. Okay. Napunta na kami sa criminal law 1 from Bravo Rose Ann, I think, coming from Angeline and coming from Mary Faye Apostol. Angeline, hindi ko alam yung surname, kapatid. Palitan mo yung Facebook mo. Hindi ko alam yung Facebook name mo. Hindi ko alam yung apelido mo. Okay. Anyway, these questions came from those students. Okay. Sabi nila, tinanong ko kasi, okay, for example, in the crime of murder or homicide, okay, what is the factum probandum and what is the factum probans? Okay. So, before natin masagot yon, okay, it is presumed and assumed that since we are already on our criminal evidence, nakuha nyo na ang criminal law 1, criminal law 2, naipasa nyo na yon. So, ang ina-assume ko lang, memorize mo na yan. Okay? Ang elements ng murder, ang elements ng homicide. Okay? Ano ang pinagkaiba ng murder or homicide? Okay. May sumagot. Yung isa, attorney, wala pong intent to kill. Yung isa, merong intent to kill. Okay. Take in mind, guys, when we speak of homicide and murder, both of those crimes involve the intent to kill of the person. Okay? Merong intent to kill yan pareho. So, ano pong pinagkaiba ng murder at homicide? Okay? You go now to your articles 248 and 249. Oh my God, hindi ako sure. Basta, tignan nyo sa revised penal code yung articles 248 and 249. Okay? Okay. So, the question that was raised by my students from section 4A is this. What is the factum probandum in homicide and what is the factum probandum? Okay. Also, what is the factum probandum of murder and in factum probans of murder? Okay. So, before ko yun sasagutin, okay, bibigyan ko muna kayo ng idea kung paano ba kami nagsimula doon sa discussions na yun. Okay. First, I asked them. Kasi hindi daw malinaw sa kanila yung factum probandum at factum probans. Okay. I was trying to give them a scenario. Sabi ko, Shay shot Dennis. Dennis died. Okay. What is the crime committed? Okay. Ngayon, okay, tapos yun ang criminal law 1, tapos yun na rin ang criminal law 2. Okay. So, I'm assuming that you already know the answer to these questions. Okay. Okay. Alam niyo na yung mga elements. Master nyo na yan. So, okay. What is the crime committed? Okay. May sumagot, homicide. May sumagot, murder. May sumagot, murder with treachery. Okay. Remember that the facts are stated and do not presume facts, okay, that are not stated. Okay. Okay? So, unless it is specifically stated, huwag po tayo mag-assume. Okay. So, homicide versus murder. Okay. Yun yung parang dalawang sagot. Okay, na naglalaban. Okay. So, tinanong ko, what is the difference between homicide and murder? Okay. May sumagot, yung homicide po, attorney, wala pong intent to kill. Yung murder po, meron. Tama ba yun? Okay. Nagkakaroon tayo ng technical difficulties. Okay. So, tama ba yun? Okay. Sabi ng isang estudyante, yung ano po, yung homicide po, wala pong intent to kill. Okay. Yung isa po, meron. Okay. So, we go now to the articles defining homicide and murder. Okay. You go to articles 248 and 249 of the revised penal code. Okay. The elements of homicide are as follows. Article 249, I think. Okay. Number 1, okay, a person was killed. Okay. Number 2, okay, the accused killed him without any justifying circumstances. Number 3, okay, the accused had intention to kill, which is presumed. Okay. And number 4, the killing was not attended by any of the circumstances which would have elevated the killing into murder. Okay. That is the element of homicide. Okay. Now we go to Article 248, which defines murder. Okay. Under this, okay, sabi sa Article 248, okay, a person shall be guilty of murder if he, okay, kills, okay, a person under the following circumstances. Tapos, in-enumerate yun. Okay. Treachery, taking advantage of superior strength, a band, armed men, okay, in consideration of a price, reward, or promise. Itong mga circumstances na in-enumerate under Article 248, actually, these are the aggravating circumstances also found under Article 14. Tama ba? Under Article 14 of the Revised Penal Code. Check nyo na lang yan. Balikan nyo yung ano. So, ang ibig sabihin, okay, ang pinagkaiba lang ng homicide at murder is that murder involves an aggravating circumstance. Okay? Both of these crimes, okay, involves an intent to kill. Okay. And the fact of death. This intent to kill is presumed on the fact of death. Only that in murder, the killing is attended by circumstances which would elevate it to murder. Yun yung aggravating circumstances. Yun yung treachery. Yun yung sagot ng isang estudyante. Okay. So, balik tayo dun sa scenario ko. Shay shot Dennis. Okay. Dennis died. Okay. What is the crime committed? Okay. In the facts, there are no aggravating circumstances. So, the crime is obviously homicide. Okay. Doon, natapos na yung debate namin sa group chat. Okay. The crime is homicide. Okay. Now, what are the factum probandum for homicide? Actually, pag tinanong ang factum probandum, ang sinasagot mo actually na tanong dyan ay, paano mo maipoprove yung crime? Paano mo maipoprove yung homicide? Okay. So, babalik ka sa criminal law 1. Paano mo maipoprove ang homicide? You show that all the elements are present. So, bumalik ka sa article na nagpo-provide, nagde-define ng elements ng homicide. Okay. So, the factum probandum, okay, which are actually the elements of homicide, are a person was killed. Okay. That the accused killed him without any justifying circumstances. Okay. That there is intent to kill. Okay. The intent to kill which is presumed by the fact of death. And number 4, that the killing is not attended by the aggravating circumstances which would have elevated the killing into murder. So, itong apat na ito ang iyong factum probandum. Ito yung proof para ma-establish mo yung crime ng homicide. Kung present itong apat na ito, okay, ma-convict yung accused sa homicide. Okay, now, paano mo naman maipoprove itong factum probandum? Okay. Diyan darating ang factum probans, which are the evidentiary matters. Okay. So, number 1, a person was killed. Okay. Paano mo ito maipoprove? Okay. Pwede yung death certificate ni Dennis. Okay, kasi namatay siya. Pwede rin dalhin mo mismo yung katawan niya na patay. Okay. Joke. Death certificate. A person was killed. Okay. Next. Okay. Intent to kill, which is presumed. Okay. Yung intent to kill, the fact na namatay si Dennis is presumed na yon. Okay. This is an exception. Okay. Of the rule that all matters should be proven. Okay. I-discuss ko yun later. Okay. Intent to kill. Okay. Yung intent to kill, mapoprove mo na yon by the fact of death. Okay. Next. Okay. That the accused killed him without any justifying circumstances, etc., etc. Okay. So, in this case, okay, paano mo pa maipoprove yung intent to kill? Pwedeng yung murder weapon. Present mo yung baril. Okay. Present mo yung baril na ginamit ko. Okay. In that case, yung death certificate ni Dennis at yung murder weapon na ginamit ko at isa pang eyewitness na nagsasabing, nakita ko si Shay, binaril na si Dennis. Those facts, okay, are the evidentiary matters that are actually the factum probans which will prove the crime of homicide, okay, which will prove the factum probandum, the elements of the crime of homicide. Okay. So, yung factum probans, okay, yun ang evidence para ma-prove mo ang elements. Ang elements ang mag-establish ng crime. So, malinaw na ba tayo doon sa factum probandum and factum probans ng homicide? Next scenario. Shay shot Dennis using an unlicensed firearm. Okay. Dennis died. What is the crime committed? Oh, very obvious na. Kakatapos natin homicide. Okay. The crime committed is murder. Why? Because there is an aggravating circumstances. Meaning, the killing is attended by a circumstance which elevated it into murder. What is that circumstance? That the killing was done by the use of an unlicensed firearm. Okay? Gets? Okay. So, dahil ang unlicensed firearm, murder siya. Okay. Ngayon, what are the factum probandum of murder? Okay. So, the fact of killing. Okay. The intent to kill, which is presumed by the fact of death. Okay. At ano pa yung isang factum probandum? Yung aggravating circumstance, which is the use of unlicensed firearm. O, yung tatlong yun ang factum probandum mo. Ano ang factum probans mo? Same lang din. Okay. That certificate, intent to kill. Okay. Tapos, yung fact that the firearm was unlicensed. Okay. Which can be proven by a certification coming from the PNP that Shay doesn't have a license to own or possess that firearm. So, yung certificate na wala akong right to own or possess the firearm, yung that certificate na din is, yung mga yun ay factum probans, to prove the factum probandum which will establish the crime of murder. Okay. So, naintindihan natin yun. Dahil dun sa discussions namin na yun, mayroon ulit silang tanong, okay, sa section A, okay. Sabi, okay, I think it is Angeline. Kasi ang kadiscuss ko noon is Bravo, Angelito, Marife. Angeline. It was Angeline. I don't know the surname. Angeline sent me a reading, a picture of a book, a page of a book. Kasi di ba diniscuss ko, intent to kill is presumed, okay, in homicide and in murder. Okay. Tapos, nabasa niya, may nabasa siya sa isang libro. Ito yon. Okay. Let me just back read. Okay. Okay. Ipopost ko yun dito. Ito yung nabasa ni Angeline. Okay. So, basahin natin sa book. But killing a person with treachery is murder even if there is no intent to kill. Okay. So, naguluhan si Angeline. Sabi niya, Attorney, sabi niyo po kanina, yung homicide sa murder, may intent to kill po yun, na presume. Bakit po dito sa nabasa kang libro, sabi, killing a person with treachery is murder even if there is no intent to kill? Ang ibig sabihin po ba nito, pinatay niya nang walang intent to kill, pero murder pa rin. Okay. This is the scenario. Okay. If you're going to read the book, okay, the citation is People versus Kakgoko. Okay. 58 Philippine Reports 530. Okay. Ano ba ang nangyari dito sa People versus Kakgoko? Okay. Dito kasi, the accused, okay, so, pangalanan natin yung akusado para chika-chika lang, okay. So, syempre, pag akusado, Dennis na yan, okay. So, Dennis, okay, so, sino ang gustong kalaban ni Dennis? Okay, si Angelito, siyang naalala ko. Dennis, so, Angelito, nagkatitigan sila, masakit na titigan, okay. Nagka-kursunadahan, if that is the term. Okay. So, kinursunada ni Dennis si Angelito. Okay. Dahil sa masakit na tinginan, sabi niya gano'n, okay. Si Dennis, sinugod niya si Angelito. Kasi gusto niyang ipakita na siya yung mas magandang lalaki. Siya yung mas matapang. Kaya hindi dapat siya tinitignan ng masakit. Okay. So, si Dennis, sinugod niya si Angelito, sinuntok niya. Gusto niya sanang trip lang. Sinintok niya, tapos yung suntok nagland sa ulo. Okay. Si Angelito, dahil medyo lampa, natumba, tapos nadulas, nabagok yung ulo. Namatay. Okay. So, during the case, sabi ni Dennis, wala akong intent to kill. Hindi ko naman intensyon na patayin si Angelito. Ang intensyon ko lang ay saktan siya. So, because I have no intent to kill, meaning, hindi dapat homicide ang kaso ko. Kasi sabi sa homicide, isa sa elements ng homicide, isa sa factum probandum ng homicide ay ang intent to kill. Sabi ni Dennis. Okay. Dapat ang kaso ko, physical injuries lang. Kasi yun lang naman yung intention ko eh. Ang intention ko lang saktan siya. Hindi ko siya intention patayin. Okay. Is that correct? Okay. In that case, ang ruling ng Supreme Court is in relation to Article 4. Okay. Article 4, yung paragraph 1, I think, yung mistake went beyond, the blow went beyond the intent. Parang ganon. Okay. Criminal law 1. Of course, ang ruling ng Supreme Court, even if you have no intention to kill, the fact na napatay mo yung tao, okay, meaning intent to kill is presumed. Okay, dapat pag binasa mo yung batas, huwag kang titigil dun sa intent to kill. Okay. May kasunod yon, which is presumed by the fact of death. Okay. Bakit? Okay. Kasi napatay mo na siya. Meaning, all the elements of the crime are already present. Okay. Ngayon, attorney, kailan lang po nagmamatter yung intent to kill? Okay. Yung intent to kill, it only matters if the victim did not die. Ang ibig sabihin, pag hindi namatay yung biktima, dun mo lang i-consider ang intent to kill. Okay. Para malaman mo kung ang crime ay frustrated or attempted murder or homicide or physical injuries lang, okay, as the case may be. Okay. So, yung mga yon, importante lang yon para malaman what was the actual crime committed. Diyan na yung babalik kayo sa criminal law 1, yung mortal wound doctrine, di ba? Yung sa kung saan yung wound, okay, babalik na tayo sa criminal law 1, hindi ko na yung gagawin. Okay. So, hanggang doon na lang. Just to answer the question of one of the students in relation to our topic. Okay. So, nagets nyo na ba yon? Yung homicide and murder, okay, factum probandum and factum probans. Okay. So, malinaw na tayo doon. Okay. Wala nang ibang questions. Okay. So, kung wala na tayong ibang questions, pwede na tayong mag-move on. Pwede na tayong mag-move on sa next topics. Okay. Next topics. Meron pa bang questions? Wait, give me a moment of silence to go over our conversations in Facebook, just to know if there are questions. Baka meron pa ba? Okay, wala na ata. Okay. Okay, so i-wrap up na natin yung last lecture. Okay, so we have defined evidence. Okay, so evidence is a means sanctioned by section 1. So natapos natin ng section 1 to 3. Okay, tama? Ng rule 128. Definition of evidence. Okay, for elements, evidence is a means sanctioned by the rules in ascertaining in a judicial proceeding the truth respecting a matter of fact. Okay, so evidence is a means, okay, sanctioned by these rules, meaning under rules 128 to rules 133. Okay, and ascertaining in a judicial proceeding meaning the rules of evidence are only applicable to a case which has been filed in court. Question: are the rules of evidence applicable in the barangay? No, because the barangay is not a court. Okay. Are the rules of evidence applicable in a labor case, in LRC? No, kasi it is not a court, it is not a judicial proceeding. Sa Civil Service Commission, yung mga administrative cases, are the rules of evidence applicable? Again, no, because the Civil Service Commission is not a court. It is only an administrative proceeding which exercises functions, okay, the same way as the court does. So it has judicial functions, although it is an administrative body. Anyway, because they are not courts, okay, the rules of evidence are not strictly applied. Okay, the truth respecting a matter of fact. Meaning, you only apply the rules of evidence if the issue, okay, is concerning, okay, a fact, okay, in relation to the case. Okay? Discuss ko yan later on sa section 4, doon na sa admissibility. Okay? And, so yan yung section 1. And then, section 2, nandun yung principle of uniformity of the rules. Meaning, the rules of evidence shall be applied, okay, in the same way, in all courts, in all proceedings, okay, in all hearings, okay, in all trials, pare-pareho yan. Kung ano ang rules of evidence sa MTC, sa RTC, same yan. Okay, same rules of evidence. Okay. Now, in relation to this section 2, we have discussed the doctrine of judicial stability. Okay, na-discuss ko na yan. The doctrine of hierarchy of courts. The doctrine of adherence of jurisdiction, I think, na-discuss ko rin. So, ano pa ba? Okay. Now, Section 3, admissibility. Okay. In Section 3, admissibility, there are only two important aspects. Okay. Relevancy and competency. Okay. Sinabi ko, pag sinabi nating relevancy, all facts, okay, having rational probative value are admissible in court. Okay, memorize nyo yun. Okay. Sobrang technical, pero anong ibig sabihin nun? Ng axiom of relevancy. Ang ibig sabihin, i-accept lang yung ebidensya kapag ang pinoprove nun na matter ay connected sa kaso. All facts having rational probative value are admissible in court. For example, okay, in the case of concubinage. Okay. O, ano ang concubinage? Criminal law 1 na naman tayo. Pag sinabi natin pag sinabi natin concubinage, okay, the man, okay, engages in sexual intercourse with another woman, not his wife, in under scandalous circumstances. Okay. So, yung lalaki, may kabit siya, ang tawag dun sa kabit ay concubine. Pag adultery, yung babae ang may kabit, ang tawag dun sa kabit niya ay paramour. Concubinage. Okay. So, ano ang factum probandum mo sa concubinage? Okay. For example, okay, Shay is married to Dennis. Dennis engaged in extramarital affairs with, sino ang gusto niyang kabit? Angeline. Sige. Okay. Angeline and Dennis engaged in an amorous relationship despite the fact that Dennis is married to me. Okay. The crime committed is concubinage. Now, what are the factum probandum? The fact of marriage of Shay and Dennis. Okay. Limit number 1. Okay. Ano pa ang factum probandum? That Dennis engaged in sexual intercourse with Angeline. Okay. What else? That Dennis, okay, that the sexual intercourse or the sexual relationship was made under scandalous circumstances. Yan ang factum probandum mo to prove the crime of concubinage. Correct? O, ano ang factum probans mo? The fact of marriage, factum probandum. Ano ang factum probans? The certificate of marriage. Correct? Contract of marriage. Okay. That Dennis, okay, engaged in an amorous relationship with Angeline. Okay, yun yung factum probandum. Ang factum probans nun ay pwedeng pictures, pwedeng sex videos, pwedeng eyewitnesses. Okay? Correct? And scandalous circumstances. Okay, that the sexual intercourse was made under scandalous circumstances. Same evidence. Pwedeng a sex video, di ba? Or that meron silang naging anak, may anak sila sa labas. O yun na yung pinaka-ebidensya that they had sexual intercourse. And that is scandalous circumstances. Kasi nagkaroon ng bunga ang kanilang amorous relationship. So, ito ang factum probandum. Ito ang factum probans. Okay? Gets? Okay. So, bumalik tayo dun sa factum probans. Ano ang relevant evidence? Okay, axioms of relevancy. Ang relevant evidence dyan ay, of course, yung factum probandum at yung factum probans. Those are relevant evidence. Those are facts having rational probative value which will prove the fact in issue. So what if during the course of the trial, okay, ang pinesentang evidence ay the fact that I am also engaged in an amorous relationship. Okay, sabi ni Dennis, ay, meron din naman siyang ibang relasyon. Okay. Would that, okay, be relevant on the case? Okay. Of course not, because it does not tend to prove, okay, the fact in issue. Okay. Ang issue dito yung crime or concubinage committed by Dennis. Okay. What else? Okay. Pwede ba magpresenta si Dennis ng evidence proving or tending to prove that I am a lesbian, for example. Okay. Ang pinipresenta ni Dennis, kasi lesbian yung asawa ko. Okay. Is that relevant? Is that, okay, does that evidence stood or stand, okay, over the test of relevancy? Is it relevant? No. Okay. Therefore, dahil hindi yun relevant, hindi yun admissible as evidence. Okay, gets. Okay. Because under section 3 of admissibility, the evidence must be relevant. Okay. Yun yung axiom of relevancy, meaning all facts having rational probative value are admissible in court. Okay. Ito yung first element. The second element, the second axiom of admissibility is competency. Meaning, all facts having rational probative value are admissible unless, okay, excluded by a specific law or rule. Okay. So, yun ang competency. Okay. All relevant evidence, lahat ng evidence which are relevant are actually admissible for as long as they are not excluded by the law or by the rules. Okay. So, last lecture, diniscuss ko sa inyo yung Ramirez versus Court of Appeals ata. Yun yung dentist na nahanapan siya ng love letters sa kanyang drawer. Correct? Okay. So, ano pa ang isang example? Okay. Para mapakita natin yung relevancy and competency. Okay. Rose is a reporter. Okay. Dennis is a police officer. Okay. Dennis killed Rose. Okay. Prior to the killing, there was an altercation. Okay. Meaning, nagkasagutan pa si Dennis siya si Rose. Okay. Tapos, dahil dun sa nagkainitan sila, okay, si Dennis, napatay niya si Rose. Okay. Before the killing, Marife, who was also a radio reporter, was able to tape record, na-record niya, okay, yung altercation, yung heated argument ni Rose at ni Dennis. Okay. During the trial, okay, the tape recorder was being presented. Okay. Pinipresent nila yung tape recorder to prove, okay, that it was the police officer who killed, okay, it was Dennis who killed Rose. Okay. Kasi, pinuprove, circumstantial yun, I think. Okay. Ngayon, is the tape recorder relevant? Okay. To prove that there was a heated argument between Rose and Dennis. Is it relevant? Meaning, mapuprove ba niya na nagkaroon ng altercation muna si Dennis tsaka si Rose? Is it relevant? Yes. It will actually prove that there was an altercation immediately preceding the killing. Correct? Okay. Question. Is it competent? Okay. Will it stand? Will it overcome the test of competency? Is it excluded by the law? Is it excluded by the rules? Yun ang tanong sa competency. Okay. Masasabi mong competent ang isang ebidensya kapag walang nag-exclude sa kanya na batas. Okay. In this case, the tape recording is actually in violation of what particular law? RA 4200. The Anti-Wiretapping Act. Which prohibits a person from recording, okay, a conversation without the consent of any party. Correct? So, ang ibig sabihin, hindi siya competent because there is a specific law, okay, which, okay, exclude, okay, that evidence. Okay, meaning, hindi siya admissible. However, okay, if you are going to follow the reasoning, yun dapat yun, hindi siya competent. Okay? Kasi there is a specific law which prohibits. Okay? However, in the case of People versus Navarro, okay, People versus Navarro, I will give you the citation later. Okay. Sabi ng Supreme Court, yes, okay, it is actually excluded by a particular law, particularly RA 4200. However, there is no reasonable expectation of privacy. Okay. Hindi naman kasi yon private conversation. Okay. Kasi maraming tao, okay, nung nangyari yung altercation, sabing ganon ng Supreme Court. Meaning, wala kang binabiolate na right to privacy. Okay? Wala kang binabiolate na law because actually it was made in public. Kaya, yung tape recorder is admissible. Okay? That was the ruling of the court in People versus Navarro. Okay? So, inadmit nila yung evidence. Okay. Okay. So, those, I think, na-discuss naman natin lahat na doon sa previous na course outline. Kung meron pa ba akong... meron pang question. Direct versus... positive versus negative evidence. Positive evidence, madali lang. Okay. It is an evidence tending to affirm a particular fact. Kapag negative, tending to disprove a particular fact. Okay. Dito tayo sa direct versus circumstantial. Okay. Direct evidence pertains to an evidence which needs no inference. Okay. Meaning, pag nakita mo yon, hindi na kailangang explain yung ebidensya. Okay. By the mere fact of its existence, yun na yon. Okay. Like circumstantial, meaning, kailangan mo ng inference. Kailangan mong alamin, kailangan mo pagsamasamahin yung circumstances, okay, to prove a specific point. Ano ba ang magandang direct evidence? For example, Shay is married to Dennis. Okay. And there is a sex video. Dennis and Rose. Oy, Rose, huwag kang magagalit sa akin. These are only fictional. This is not true to life. Kilala nyo naman ako mag-lecture. Okay. So, the sex video, is it direct or circumstantial? It is direct. Okay. Kasi, yun na, sex video, nag-around sila ng sexual intercourse. And the fact that it was recorded, meaning it is scandalous. Tama? Okay. What if, okay, Shay is married to Dennis, and Dennis was seen holding hands with the Rose sa Baywalk? Direct or circumstantial? Okay. Tapos, Rose is seen riding in the car of Dennis. Rose and Dennis checked into a hotel, was seen checking into a hotel. And then, they were seen leaving the hotel. Those circumstances, those are circumstantial evidence. Okay. Kasi hindi naman direct. Okay. So, what else? Okay. What if, okay, in the case of rape, I hope you guys are not sensitive. Okay, we call a spade. We're studying criminal law. Okay. The shorts, okay, of a girl, or the underwear of a girl was seen on the bag of the accused. Okay. What is that? Is that direct or circumstantial? Okay. That is circumstantial. Basta ganun lang. Pag direct, okay, yun na mismo. Okay, what else? Okay. A raped B. Okay. C saw the act of raping. Okay. C now is offering her testimony. Okay. Eyewitness siya. Okay. Is the eyewitness, okay, direct or circumstantial evidence? Eyewitness. It is direct. Okay. Direct evidence yun. Hindi yung circumstantial. Okay. Kasi it's the best. It is based, on his personal knowledge. Okay. Meron pa ba? Meron pa ba akong nakalimutan doon sa last lecture? Wala na. Okay. Since wala na, let's move on to our next, okay, topic under the course syllabus. Okay. So, please kindly get your syllabus. Okay, kindly get your course outline for criminal evidence. We will now go to the second topic, which is Rule 129. Also, patalastas. To those who are asking what you need to pass the subject, this is the rules of court. Okay, basa ba? Okay. Okay. Okay, kung so, this is the rules of court. Kung makakalabas kayo, bumili kayo ng rules of court. Okay? Kaya lang kasi, ang gagamitin nyo lang dito sa rules of court for evidence ay ang Rule 128 to Rule 133. Ito. Ganito kalaki yung rules of evidence. Okay? Pero, ang kailangan nyo lang dito, ganito lang ito lang. Rule 128 to Rule 133. So, kung gusto nyo mas makatipid, kahit na wag nyo nang bilhin yung buong rules. Kasi may civil procedure pa dito Kahit pumunta na kayo sa law field, i-download nyo na lang yung Rules 128 to Rules 133. Yun lang naman yung kailangan nyo. Tignan nyo, shucks. Ganito lang siya kakapal. O, diba? Ganito lang kakapal yung kailangan ninyo dun sa rules. So, for practicality, tsaka kung hindi kayo makalabas, i-print nyo na lang yung sinend ko sa inyo na link from law field. Okay? Ito yung gamit ko. Tapos, yung Riano. Okay? But be very careful. As I've said, be very careful in reading Riano and other materials kasi it is presumed that you already have a foundation, you already have mastered the general principles of criminal law. Parang yung kanina, yung si Angeline, okay? But, I really appreciate the fact that you are reading, that you're asking questions because it means that you're interested on the subject. Okay, so, ito yung ginagamit ko. Ito yung kailangan nyo. Hindi ko ginagamit. So, ito yung kailangan nyo para makagawa kayo ng reviewer. I have also sent a copy of the reviewers. Okay. So, wala na ba tayong nakalimutan sa first lecture? Wala na. Okay. Wala na. So, next, okay, we go now to rules, to the second, topic, which is Rule 129. Okay, so, pumunta na kayo sa Rule 129. Okay. What did not be proved? I-copy nyo na yung Section 1. Okay. Yung Section 1 actually is judicial notice. Okay. Now, there are two kinds. Okay, so bago yan. Okay. As a general rule, all matters which are relevant and competent shall be proven by evidence. Okay, yan ang general rule. Exceptions ay the following. I will put a enumeration here. Okay. So, as a general rule, all matters which are relevant and competent in the case must be proven. Okay? Kasi, di ba, those who alleges must prove. Okay? So, lahat ng matter, should be proven. Okay? However, there are several exceptions. Yan na yung mnemonics ko. Yung Japaki. Okay? Ang number 1 ay judicial notice. Okay? Number 2, facts which are admitted. Number 3, facts which are presumed. Parang yung kanina, yung sa homicide. Okay? Intent to kill. Presumed. So, kahit na hindi mo na-prove yun. Kasi, the fact na namatay siya, presumed na yung intent to kill. Okay? So, ulit. Judicial notice. Facts which are admitted. Meaning, inadmit na. Okay? Facts which are matters which are presumed. Okay? Matters which are agreed upon. Okay? Matters which are solely under or exclusively under the knowledge of the opposing party. Okay? And matters which are irrelevant. Okay? Parang yun din. Kasi hindi nga siya relevant. So, irrelevant siya. Hindi mo na siya kailangang i-prove. Okay? So, now we will be starting with judicial notice, which is one of the matters which did not be proven. Okay? Yun yung dinidefine ng Rule 129. Actually, when I was a student, I memorized this section. Okay. Rule 129, Section 1 and 2, Judicial Notice. Okay. There are two types of judicial notice. Okay. Mandatory judicial notice and discretionary judicial notice. Okay. Okay. Pag sinabi natin judicial notice, ang ibig sabihin, hindi mo na to kailangang i-prove sa korte. Okay. Kasi it is of the nature na alam na ng lahat ng tao na this is true as a fact. Okay. So, ano ang judicial notice? Okay. Number 1. Ano ang mandatory judicial notice? Okay. Number 1. The existence and territorial extent of states. Okay. Ang ibig sabihin, existence ng Philippines, existence ng USA, existence ng countries. Kailangan mo pa bang i-prove Kailangan mo pa bang i-prove na may bansa na nag-exist ng pangalan ay Pilipinas? No, that is already mandatory judicial notice. Next, okay. The political history, forms of government, and etc. Okay. Halimbawa, the fact that North Korea is a communist party. Okay. Meaning, yung fact na yun, hindi mo na kailangang i-prove. Kasi mandatory judicial notice, hindi mo na kailangang mag-provide ng ebidensya na magpakita na ang North Korea is in a communist form of government. Hindi na. Kasi mandatory judicial notice. What else? The law of nations. Okay? Next. The Admiralty and Maritime Courts of the World and their seals. Okay. Number 5. Okay. The political constitution and history of the Philippines. So, ito yung 1973, 1987 Constitution. Hindi mo na kailangang i-prove yan. Next, okay. The official acts of the legislative, executive, and judicial departments of the Philippines. Okay. Next, the laws of nature. Okay. Example, the laws of nature. Kailangan, for example, nasa second floor ako. Okay. Gusto kong patayin si Dennis, nasa baba. Ang ginawa ko, kumuha ako ng paso. Okay. Hinulog ko. Okay. Kailangan ko ba bang i-prove ang laws of gravity na pag ang paso hinulog ko, na ang paso pag binitawan ko sa second floor ay mahuhulog sa ulo ni Dennis? Hindi na, because that is the laws of nature and it is of mandatory judicial notice. Okay, next. Okay. The geographical divisions. Alam niyo na to. Basta minemorize niyo yung Article 1 ng Constitution, yung national territory. Okay, yung mga teritoryo ng bawat bansa. That is also mandatory judicial notice. Okay. That is what is provided under Section 1. Yung mandatory judicial notice, the court cannot refuse to take judicial notice of this, okay, of this matters. Ibig sabihin, kapag forms of government, kapag laws of nature, okay, the laws of time, halimbawa, that there are 24 hours in a day, that there are 60 seconds in 1 minute, hindi mo na kailangang i-prove yun. So, pag inask ka ng court, okay, na i-prove na for that particular day ay 24 hours, hindi na kailangan. Okay? It's common sense. Kaya nga mandatory judicial notice. Okay? There is another type of judicial notice, however. Ito yung memorize ko hanggang ngayon. Kasi syempre, yung judicial notice na discretionary, after ng bar exams, kinalimutan ko na yan. Pero memorize ko yan noon. Okay? Since kayo naman na magbo-board ngayon, kayo naman na mag-exam, o di kayo mag-memorize. Okay. But anyway, the discretionary judicial notice are actually, okay, those matters, okay, which withstand, okay, the test of notoriety. Okay. May tatlong elements, okay, ang discretionary judicial notice. PDF, number 1. Okay. Matters which are of public knowledge. Okay. Matters which are of public knowledge. Number 2. Matters capable of unquestionable demonstration. Okay. And number 3. Okay. Matters which are ought to be known, okay, by the judge because of their judicial functions. Okay? Yun yung tatlo na discretionary judicial notice. Okay, so we are now discussing the discretionary judicial notice. Okay, and there are three groups of discretionary judicial notice. Number one, matters which are of public knowledge. Matters which are of public knowledge. Number two, okay, matters which are capable of unquestionable demonstration. Okay, and number three, matters which are ought to be known by the judges by reason of their official functions. Okay, now, on the first group, matters of public knowledge. Okay, may three elements yan. Number one is the test of notoriety. Okay, pag sinabi natin test of notoriety, ang ibig sabihin, the matter is notorious and is publicly known. Okay, ang ibig sabihin, alam ng lahat, it is common knowledge, and everybody knows that that matter is a fact. Okay, number two, the matter must be well and authoritatively be settled and not doubtful. Ang ibig sabihin, walang doubts, okay? Walang agam-agam na yung matter na yun ay totoo. And number three, that the matter must be within the territorial jurisdiction of the court. Okay. Ano ang examples nitong matters of public knowledge? Yung locations of hospitals, locations of rivers or lakes doon sa particular place na yon. Okay, locations ng bridges, ng banks, okay, ng restaurants. Those are of public knowledge, meaning the court can take discretionary judicial notice. Okay, ang ibig sabihin ng discretionary, discretion, meaning may kakayahan, okay, or may prerogative ang korte na i-accept yon as a judicial notice or hindi. I-accept yun as a fact or hindi. Okay. Next, okay, is the second group are matters of unquestionable demonstration. Ang ibig sabihin, yung matters of unquestionable demonstration is hindi sila notorious. Okay. Diba doon sa public knowledge, dapat notorious, meaning publicly known and authoritatively settled. Dito, hindi sila notorious. Pero, okay, pag dinemonstrate mo sila, capable of unquestionable demonstration, yun talaga yung magiging result. Okay, for example, the fact that poison kills. Okay, kailangan mo pa bang i-demonstrate na pag uminom ka ng lason ay mamamatay ka? Okay, the fact that if you shot a person on the head, the fact that that person would die. Okay, kailangan mo pang i-demonstrate yun? Hindi na. Okay? Yun. Those are matters of unquestionable demonstration. Okay, so, discretionary judicial notice. Okay. And the last type of discretionary judicial notice is those matters that are ought to be known by the judges by reason of their official functions. Ano yung mga yon? Okay. Yun yung mga matters, halimbawa, yung attitude of the witnesses. Okay. Okay, yung demeanor ng witnesses during testifying, kapag doubtful, okay, judicial notice na yon, when the witness could not answer properly, okay, and there are inconsistencies, okay, what else, okay, the decisions of the Supreme Court, case laws, jurisprudence, the rules, those are matters ought to be known by the judges. Okay. What if, for example, okay, there is a judge, okay, sabi natin, gawin nating judge si Angeline. Okay. Angeline is, for example, a judge. Okay. Angeline was walking through Baywalk. And, dun sa Baywalk, nakita niya na may manhole. So, naiwasan niya. So, nag-walking dun si judge, alam niya na may manhole. Kasi dumaan siya doon. Okay. The next day, si Angelito, nag-bike siya sa Baywalk. Tapos, nahulog siya doon sa manhole kasi hindi niya alam. Okay. So, pagdating ng hearing, okay, the judge, okay, knows, of course, that there is a manhole in that particular place, Baywalk. Could we say that the court could take discretionary judicial notice of the presence of the manhole? Magpa-fall ba yun sa third category, which is matters ought to be known by the judges by reason of their judicial functions. No. Kasi the fact that the manhole is there, even if it's within the personal knowledge of the judge, okay, is not a matter that is ought to be known by the judge by reason of his official function. Okay. So, hindi pwede ang discretionary, hindi niya pwedeng exercise ang kanyang discretion para i-take yung fact na there is a manhole on that place, okay, for purposes of determining whether the court can take judicial notice of such fact. Okay? So, those are the coverage of the second discussions as provided under your course outline. I will just be discussing judicial admissions on the next videos, I think. And again, if you have any questions relating to the subjects that were discussed on this video, you can collate. You can give it to your class middle, and the class middle will just collate, and I will be answering these questions for you before I upload the videos on the next topic.